But on occasion, cases that appeared to deal only in purely economic regulation did end up addressing the issue of Jewish participation in the capitalist economy. And the example I've chosen for this point is the case of Tyson Brothers versus Bantam, which was decided in 1927. And this was the case in which New York's ticket scalpers anti-ticket scalping statute was challenged. The state had capped surcharges that ticket brokers could levy on the tickets they sold at 50 cents. And Marshall challenged this as a denial of rights to property under the 14th Amendment. This practice of ticket scalping had drawn public ire and editorial condemnation after World War I, and several cities and states had tried to ban the practice. For the most part, state courts had turned away these restrictions on the very grounds that Marshall ends up arguing before the Supreme Court. Any price-fixing case was likely to win during this time. And but Marshall's brief gives us a sort of great sociological window into the ticket broker industry in New York, and that's part of what's interesting about this brief. He talks about how licensed brokers and agencies served a legitimate purpose. They provide services to upscale clients, about which Marshall knew a great deal himself. They often set up shop in swank New York hotels, and they even helped underwrite the upfront expenses of theatrical productions. They were often forced to take batches of tickets months prior to opening night. But nevertheless, the District Attorney of New York was determined to wage war on the brokers, arresting them for criminal violations of the statute and shutting down their otherwise legitimate operations. Here, Marshall's determination to ensure that all citizens had the right to compete equally and freely in the market dovetails with his economic conservatism. Many of the longest-serving agents and brokers in the ticket distribution industry in New York were Jewish. Interestingly, Marshall does not acknowledge this fact in his brief. Instead, Marshall goes after a New York State Court of Appeal judge, Judge Irving Lehman, who, as it turns out, was on the board of directors of Temple Emmanuel with Marshall. And so the brief is sort of an interestingly revealed private conversation that Marshall is conducting in a very public venue. But Marshall has a reason to be angry, at least I think he does. Judge Lehman had upheld the ticket scalping law and asserted that the legislature's intention was to stop the practice of extortion in the brokerage industry. Marshall angrily retorted that the legislature had exhibited no such intent, and this is a quote, "There is not a word in the enactment itself which deals with or defines extortion, fraud, or exorbitant rates. These words are mere epithets, a legislative calling of names and making of faces, and therefore futile." But this kind of name-calling mattered especially when the person accused of extortion was Jewish. For Marshall, such invocations of the Shylock stereotype, however subliminal, had to be dispatched with forceful haste. Free negotiation between reputable firms and knowledgeable buyers in this constitutional worldview was the hallmark of American constitutional capitalism, and the state had no business interfering. Marshall's extended deconstruction of Lehman's opinion seemed to carry a hidden message. The judge was, perhaps unwittingly, opening the door for non-Jews to believe that the state law was aimed particularly at Jews. What Marshall was really saying was that he rejected Lehman's implicit acceptance of the ethnic stereotyping of Jews that might have been embedded in the public's hatred of the ticket scalpers. Oh, good. The court stayed out of this intramural argument and gave Marshall the victory that counted, striking down the statute by a vote of 6-3. Justices Stone, Brandeis, and Holmes dissented in opinions that presaged the demise 7 years later of the affected with a public interest doctrine that the court had used for nearly 40 years to measure which legislative interferences with the market were permissible and which were not. And the quote from Holmes that everybody uses is too good not to use here. "The notion that a business is clothed with a public interest and has been devoted to the public use is little more than a fiction intended to beautify what is disagreeable to the sufferers." Evanescent as Marshall's victory in this case may have been, it reveals for us the essence of his civil rights jurisprudence. Ultimately, he believed in the equality attainable through market relations and market exchange. He attacked racial classifications when they obstructed those relations and interfered with that exchange. And in this, he was an accurate barometer of the moderate, deferential civil rights movement of the pre-World War II era. His commitment to racial equality did not involve an attack on existing social institutions, practices, and preferences. In all of these, he was as firm a believer as any Upper East Sider who could trace his families to the Pilgrims. And as I've said earlier, the paper will eventually provide an account of the many examples in which Marshall acted as counsel for the situation. These episodes usually occurred in his capacity as president of the American Jewish Committee, a position he held from 1912 until his death in 1929. I would actually put the Ford libel suit settlement in this category. He had no client in the case. He was approached completely behind the scenes by the Ford people. Also, here I'll talk about his work on the abrogation of the 1839 treaty with Russia, under which American citizens who were Jewish were denied entry to the country, and the 1928 accusations of blood libel by the police chief of Messina, New York, a small town on the Canadian border. In each of these episodes, Marshall was able to obtain the right result. The first two earned him widespread public approval. But his unilateral handling of the Messina incident, which was actually hardly a departure from practice with him, was met with critical editorials in the Jewish press for the first time, and the criticism shook him. He was unaccustomed to having his judgment questioned and his effectiveness as a leader discounted. As in the Ford matter, Marshall assumed that the extraction of a properly worded, deferential apology would provide the needed moment of reconciliation. It did, but then that moment was over, and the recrimination that followed was swift and shrill. Towards the end of his life, he was less able to command unanimous consent to his methods and style, in part because of the proliferation of other Jewish defense organizations that aspired to more democratic models of leadership and decision-making. I conclude the long essay with some reflections on how Marshall was viewed by contemporaries at his death and by partisans decades afterwards. Marshall's role as a lawyer, in contrast to Brandeis' seat on the court, enabled him to act on behalf of the Jewish people and to advocate for civil rights for all, without having to justify that advocacy. For him, close public identification with Jewish causes was not something that he had to escape, as Brandeis did upon ascending the bench. Rather, he sought to change the meaning of that identification by claiming that Jewish causes were really questions facing all Americans. Clyde Spillinger's 1996 Yale Law Journal piece tells us vividly and eloquently that Brandeis' goal was to preserve his political autonomy as a lawyer. And I argue that Marshall seems to have succeeded in doing so, in part because he was spared the heightened scrutiny that would follow a Supreme Court justice, and that, in fact, followed Brandeis when he took his seat. Steeped in the contentious politics of interests and loyalties that Brandeis escaped, Marshall probably did a better job of balancing the interests of his clients with his professional goals and convictions. In short, Marshall achieved the political autonomy that Brandeis sought, but found more elusive than not. This was not because Marshall was a better Jew, and here I can't help but be provocative once more, but because Marshall may have been the better lawyer.